Hello friends, today I am going to talk about the latest laws, criminal laws that have been made applicable since 1st of July 2024, replacing the old act that are Code of Criminal Procedure, Indian Penal Code and Indian Evidence Act. Many of the people ask me whether the change which is brought into by making these new criminal laws applicable, whether it is a welcome change or not a welcome change. The answer is not clear, and one cannot give the answer in a single line or in a single sentence. We have to decide the case, we have to decide the facts, we have to decide the proceedings one by one based on the amendments, the changes, the substitutions which have been carried out, replacing the old laws in the new laws. In my opinion, the new laws cannot be called as new laws. New laws are nothing but the copy-pasted version of the old act. If all the three acts are to be seen and perused and studied upon, one can easily guess that all these three new laws are nothing but the copy-pasted versions of the old acts. 90% of the material is kept as it is. If 90% of the material is kept as it is and only 10% of the changes have been made and only the numbers have been changed, how can we call the new laws as the new laws? Because it is just a replica of the old acts. So one can say that it is a wine, the same old wine in the new bottle, as only 90% of the things have been kept as it is and only 10% of the changes have been made in the new laws and the numbers have been changed. So I feel these are not new laws, but we can call it as the amended laws. The second thing is that regarding the 10% changes which have been inculcated in the new criminal laws, that is BNSS, BNS and BSA Act, भारतीय नागरिक सुरक्षा संहिता, भारतीय साक्ष्य अधिनियम, etc. and BNS Act. If we take into look or if we take into consideration all these three new laws, then we cannot immediately say that the 10% changes which have been made in these three new laws are absolutely bad or absolutely right. In law, there is nothing which we can call as right or wrong. It depends upon the interpretation. I may find some of the sections from the new laws which have been amended very good and beneficial to the stakeholders, and someone may find it very difficult and not compatible with the provisions of Indian Constitution and not beneficial to the common man at large. So it depends upon the interpretation of the persons who are interpreting the law. But no one can say that everything is right and everything is wrong. We have to take it step by step, looking at the provisions which have been made in the new laws. On the similar lines, I have taken one section regarding the new criminal laws, that is भारतीय नागरिक सुरक्षा संहिता. So in that new law, it pertains to the old Code of Criminal Procedure. The name is now changed and it is made Bharatiya Nagrik Suraksha Sanhita 2023. In the old section, we had a section, in the old act we had a section which was numbered as 154, and the same section is there in the new act in the Bharatiya Nagrik Suraksha Sanhita, which is numbered at section 173. So I would like to make a comparative study and point out what is good and what is bad as per the interpretation of mine. I find that some of the changes which have been made into the new laws are absolutely welcome. They are praiseworthy and we should always welcome those changes. But along with welcome, I find some of the changes regarding section 173 absolutely dangerous to the interest of the stakeholders and legal fraternity, and I think there is an immediate need to carry out amendment to wipe out the bad things from section 173 based on what I think and based on the recent or previous judgments which have been passed by Supreme Court of India and Honorable High Court of various states. Section 173 and the old section 154 of CRPC, they correspond to each other. Section 154 of the old act and section 173 of the new act, they are the intersecting points between a common man and police forces. That is the section where these two fraternities meet with each other. So in a short, we can say it is a union of common man and police force. Section 154 of the old act, section 173 of the new act brings the union of the common people and the police forces. The old act was old section was 154 and the new act is 173. Now let us have a look at the good changes which are beneficial to the stakeholders, that is the clients, common man and the legal fraternity at large, by making some of the changes in section 173 subsection 1 regarding first information. First information is nothing but the information which is given to the police officer regarding the commission of a particular offense. When there is an offense, the information has to be given to the police officer, because police officers investigate the case, they can register the FIR and they can continue with the investigation. So when there is an offense which is committed, which is cognizable in nature, somebody has to give the information to the police force, and that information is given as per section 154 of the old act and as per section 173 of the new act. So giving the information of an offense which is committed to the police force is nothing but the first information. It may be given by any person. It need not be a victim. A victim can always give it, or anybody who is acquainted with the facts of the case and facts of the commission of the case, he or she can also give the first information irrespective of whether he or she is a victim or not. So what are the good changes that have been made under the new laws or the amended new laws under Bharatiya Nagarik Suraksha Sanhita under section 173 subsection 1 of the new act? Earlier, in the old section 154 of the old act, the first information could be given either orally or in writing. But as per the amendment which is made or which is carried out in section 173 subsection 1 under the new acts, the first information regarding the commission of an offense which is cognizable, it can be given orally, it can be given by writing, or it can be also be given by using electronic communication mode. So the inclusion of electronic communication media or mode is a welcome change, and it is in consonance with the changing technology. This means that if there is a commission of an offense which is cognizable one, the information regarding that commission of offense could be given by anybody either orally, in writing, or he can also give the information by using electronic mode like WhatsApp, Facebook, Gmail, or any application which carries information to the other persons. So the inclusion of the word electronic communication is a welcome change, and it is in harmony with the changing technology. Earlier, we did not have the facility of sending the first information regarding the commission of cognizable offense to the police officer via electronic mode. Now it is inculcated into the section itself under section 173 subsection 1. It is a welcome change. The second good thing which is made applicable under the new laws, that is BNSS, is that the information regarding the commission of cognizable offense can be given to the in charge of the police station irrespective of the way of the area where the offense has been committed. Now what used to happen when somebody goes to the police station to register an FIR to give the information regarding the commission of a cognizable or non-cognizable offense, the first question the police puts before you is that whether the offense which is committed lies within their jurisdiction, and if it is not, then they cannot register the FIR. For example, if the offense is committed at Mumbai, and if I give the first information to the police station which is located at Kolhapur, then the police officers of the police station of Kolhapur, they can say that since the offense is committed at Mumbai, I cannot register FIR because I don't have any jurisdictional rights. That is the tradition, which is wrong, but that is the answers which used to be given by some of the police officers to the persons who sought the registration of the FIR in the police station. Now the new law says irrespective of the area where the offense is committed. It means that even if the offense is committed at say Mumbai or Jammu Kashmir, you can give the information at Kolhapur or at Satara, Sangli, or at anywhere, irrespective of the police station within whose jurisdiction the offense is committed. That is a welcome change. Now earlier under section 154(1), we did not have the facility of registration of the FIR to any police station. For example, if the offense is committed at Mumbai, I have to register the FIR at Mumbai only as per the old law. But in the old law, in the old section also, we had various judgments of the Supreme Court of India and of the various high courts of various states, and also we had guidelines and circulars from the Ministry of Home Affairs that irrespective of the area where the offense is committed, register the FIR, and the name was given zero FIR. So in the earlier act, in the earlier section, we did not have the facility of registration of FIR, zero FIR, irrespective of the jurisdiction. We did not have that facility in the law, but we had various circulars of Home Ministry, we had various judgments of Supreme Court of India, and we had various judgments of various high courts of various states. So by using those circulars and those judgments, we used to register FIR at any police station. But we did not have the provision in the law itself, but it was there in the circulars and judgments. So zero FIR used to be registered previously also, and now zero FIR can be registered, but it can be registered if the provision is made under the law itself, irrespective of the area where the offense is committed, which is a welcome change. Very nice step which is being taken by the government as far as the amendment of the old section is concerned under section 173 subsection 1 is concerned. So these are the two changes: inclusion of electronic communication to give information regarding the commission of cognizable offense, that is a welcome change, and the provision of zero FIR in the law itself, in the act itself, in the section itself, is also a welcome change, which is very good, which is praiseworthy, and we should appreciate the efforts of the government in inculcating this change in section 173 subsection 1 of the Bharatiya Nagarik Suraksha Sanhita 2023. But a chance has been missed by the government. There are two things which I would like to point out. If the information is given by somebody regarding the commission of a cognizable offense, that information has to be signed within 3 days. So suppose if I give an information regarding the commission of dacoity somewhere by using my WhatsApp number, and if I send some WhatsApp information to the police station and request that police officer to register FIR by means of WhatsApp message, then I have been given 3 days to approach the police station and register the FIR by writing it, by signing it. Now this provision of 3 days is very dangerous. Why do I say like that? The provision should have been like this: instead of 3 days, the time span could have been curtailed to only 24 hours. If the police officer receives by electronic communication any information, then he or she should sign it by coming to the police station within just 24 hours, not 3 days. And if that person who has given the information by using electronic media doesn't turn up before the police officers within 24 hours, then it is the responsibility of the police station to go and see and check whether that person is safe or not, because that person has given some information regarding the commission of a cognizable offense and he has not turned up to the police station even after 24 hours. So the police has to worry about that person, because when somebody gives information regarding the commission of a cognizable offense, that person is under tremendous pressure. He can be pressurized by the accused, he can be pressurized by the other persons around him, he can be pressurized by his or her own family members. So the police officers have to give an opportunity to see whether that person is safe or not, because he has not come to the police station even after 24 hours. If we go by this time span of 3 days, then that is too late. The informant can be pressurized, could be pressurized, and he can say that I don't want to write or give any information. So the maximum time that should be given to the informant who sends the information by electronic media should be 24 hours, and if he doesn't turn up to the police station to sign the FIR, then the police has to go to the person, or the police has to search the person and see whether he or she is safe or not. So the 3 days provision is very dangerous, and the informant could be pressurized by some of the persons, so it should be brought within 24 hours to see whether that person is safe or not. The other provision which I think is good, and it was there in the old act also, but the government could have made better amendments in the new laws. The new law as well as the old law says that if somebody is a victim of sexual offense, and if that victim is physically or mentally disabled due to that sexual offense, then the police officer has to go to the residence of the victim and register the FIR along with a special educator or interpreter. Now this is a very good section. It was there in the old act also, it is there in the new act also. The point is, it is applicable only to the victims of sexual offense, and it is not only applicable to the victims of sexual offense, it is applicable to only those sexually assaulted victims who have been temporarily or permanently disabled. So if there is a person who is a victim of sexual offense but he is not physically and mentally disabled, then he has to come to the police station. The police cannot go to his or her home. But if she or he is mentally and physically disabled, the police can go to his or her home and register the FIR. That is discrimination. What should have been done if there is, forget about sexual offense, if there is any offense which is committed against a woman or a child or a senior citizen, then the police officers have to go to the house and the home of the victim, that is the child, senior citizen or woman, and register the FIR. Here, instead of woman, child and senior citizen, the only provision is it has to be a sexual offense, and because of the sexual offense the victim has to be permanently or physically, mentally disabled temporarily or permanently. So it's a dual precondition. He has to be or she has to be a sexually offended first, and he or she has to be permanently or temporarily disabled mentally or physically, which is too harsh. If there is a woman, if there is a child, if there is a senior citizen, and if they are assaulted, it may be a sexual assault or any assault or any offense is committed which is cognizable against these three categories, then the police have to go to their houses and register the FIR along with a special educator and interpreter. That is the amendment which should have been done under section 173 subsection 1 subsection A, which is not there. I think a government has missed a chance, but it is possible for them to make a further amendment and include this, extend this provision to the child also and to the senior citizens also, and to extend this provision to all offenses against women, child and senior citizens. Apart from that, when there is a sexual assault or sexual offense which is committed against somebody, a person, then his or her statement has to be recorded before the court, that is the JMFC, Judicial Magistrate First Class. If it is to be recorded, then as per the new laws and as per the old laws also, time limit is not specified. It only says that once there is an offense which is sexual in nature, if it is committed against a person, that person has to be taken to the court as soon as possible. What is the meaning of this as soon as possible? It may be 24 hours, 48 hours, 3 days, 4 days, 7 days. How many days? There are even cases where the statements are not recorded due to the dereliction of duties of the police officers. So there has to be a specific time limit. It has to be within 24 hours. The victim has to be taken to the judicial magistrate, and if he is not able to come to the judicial magistrate, the magistrate has to go to the victim within 24 hours. That is the change which should have been there, and time limit should have been specified, which is not specified. And I think government has missed a very good chance of including time span. If section 173 subsection 2 is to be seen, it is absolutely ambiguous. What does it say? It says that once the FIR is registered, the copy of the FIR has to be given free of cost to the informant or to the victim. There are cases where informant is different and victim is different. For example, if there is an accident and a car has hit somebody and that person is lying very seriously injured, then is it expected that the injured person should go to the police station and register the FIR? No. The persons who have been acquainted with the facts of the case, they go to the police station and they register the FIR. So in this situation, informant is different. I may have given the information regarding the commission of the accident, and the injured person is different, so he is the victim, I am the informant. Two different persons are there. This law says under section 173 subsection 2 that the copy of the FIR should be given free of cost to either the informant or the victim. The word is or. The word should have been and. The copy should be given forthwith free of cost to the informant and the victim. And what the new law says, it should be given to the informant or the victim. So any one of the persons could get the FIR copy free of cost, not both. If the informant is same and the victim is same, then there is no question of giving two different FIR copies. Here, the government should give the FIR copy free of cost to both, informant also and the victim also. So the or should be replaced with and. The interjunction should be and not or. The biggest mistake, the biggest drawback, which is even against the various circulars of the government itself and against the judgments of Supreme Court of India, is section 173 subsection 3. It is ambiguous. First, it is against the provisions of Constitution. It is against the own provisions of the Government of India regarding circulars. It is against the judgment of Lalita Kumari passed by Supreme Court of India. It is against the benefits of the common persons, and it has given unlimited powers to the police force. How? It says that if the police officer receives an information regarding the commission of an offense which is made punishable from 3 years to 7 years, then the concerned police inspector, with the prior permission of the DYSP or the superior officer, can conduct preliminary inquiry to check whether there is a prima facie case, and if there is a prima facie case, he can proceed further with the investigation. This is a clear violation of various circulars of the own government and a clear violation of the provisions and the order and the judgment which is passed by Honorable Supreme Court of India in Lalita Kumari judgment. What the judgment says? The judgment says if the information which is given by an informant to the police officer, if it discloses commission of a cognizable offense, disclosure of a cognizable offense, FIR has to be registered and investigation has to be done. Supreme Court clearly makes a distinction between commission of a cognizable offense and disclosure of cognizable offense. If you want to find out whether an offense is committed or not, investigation has to be done. And if you want to find out whether there is an offense which is cognizable or not, that is disclosure of cognizable offense or not, then there is no question of investigation. You can do preliminary inquiry. So there is a clear distinction between commission of offense and disclosure of offense. For commission of offense, investigation is must, and for investigation, FIR is must, and for disclosure of offense, FIR or investigation is not needed. What is needed is only preliminary inquiry, just to check under which category the offense falls. If it falls within non-cognizable category, then there is no question of FIR. If it falls within the category of cognizable offense, then FIR is mandatory. So the police officers have to see only if it is cognizable offense or non-cognizable offense. They need not collect any evidence. They need not proceed with the investigation. They have to see whether it is cognizable or non-cognizable. What this new law says under section 173 subsection 3 is the police officer can seek the permission of the DYSP or the superior officer to conduct the preliminary inquiry to check whether there is a prima facie case. To check whether there is a prima facie case, the police officer has to conduct investigation, and to conduct investigation, FIR is necessary, but the FIR is not mandatory as per section 173 subsection 3. So there is ambiguity. It is a clear violation of the judgment of Supreme Court of India. Police officers cannot conduct preliminary inquiry to find out a prima facie case. They have given the name of preliminary inquiry, but it is not preliminary inquiry, it is preliminary investigation. And there cannot be two investigations, one preliminary one and one final one. When you want to find out whether there is a prima facie case or not, then you have to conduct investigation. And if you want to conduct the investigation, FIR is mandatory. So by introducing this section 173 subsection 3, the government has made a violation of various judgments of Supreme Court of India. The police cannot conduct preliminary inquiry to find out whether there is a prima facie case. They can conduct preliminary inquiry to find out whether the offense is cognizable or non-cognizable, and for that investigation is not needed. And if it is disclosed that the offense is cognizable one, FIR is mandatory, and then they can further proceed with the investigation. Now under this new section, there are two investigations: preliminary investigation and final investigation, which is against the spirit of CRPC and Bharatiya Nagrik Suraksha Sanhita, and also against the various judgments of the Supreme Court of India and various circulars of the own government. There cannot be any preliminary inquiry. The police officer cannot seek the permission of the DYSP or the superior officer to conduct the preliminary inquiry. It is not permissible. It is named as preliminary inquiry, but it is preliminary or primary investigation. It has to be limited to the disclosure of cognizable offense or non-cognizable offense. The next ambiguity is this act, section 173 subsection 3, is applicable only to the offenses which have been made punishable from 3 years to 7 years. What about those offenses which have been made punishable with less than 3 years? This section is not applicable. What about the offenses which have been made punishable for a punishment more than 7 years? This section is not applicable. Why the government has chosen only one span of 3 years to 7 years? They do not say any offense which is made punishable up to 3 years. The words up to 7 years are not present. They say from 3 years to 7 years. This means that if there is an offense which is made punishable from 3 years to 7 years, this section is applicable. Why not it is applicable to the offenses which have been made punishable for 3 years. Why this section is not applicable to the offenses punishable for more than 7 years? Why the government has chosen only the time or the punishment span of 3 to 7 years? And is it not against the judgments of Supreme Court of India, especially the judgment of Lalita Kumari? There cannot be any preliminary inquiry, and if this is permitted, then there is unlimited power which is vested in the police force. They can conduct preliminary inquiry in each and every case, citing the reason of section 173 subsection 3, and they can say that since the offence is punishable from 3 years to 7 years, I can always conduct preliminary inquiry to check the veracity of the prima facie case, which is not permissible as per the judgments of Supreme Court of India. FIR is mandatory, and to conduct preliminary investigation, one has to register FIR. FIR is not registered, so section 173 subsection 3 is absolutely in violation with the judgments of Supreme Court of India, and in violation of various circulars of its own government. So these are some of the good points and some of the bad points. I think government has missed a very good opportunity, barring 2 changes. Rest of the changes are either not up to the mark or the government has missed. This is my opinion, and I hope whatever I have said is it may be agreed upon or it may not be agreed upon, but I have presented my views regarding the application of section 173 as per the new laws and its comparison with the section 154 of the old act. Thank you so much.